Thank you, colleagues. We'll move on now to the next item of business, which is consideration of Business Motion 24394 in the name of Graham Day on behalf of the Parliamentary Bureau, setting out a timetable for Stage 3 consideration of the Domestic Abuse Protection Scotland Bill. Could I call on Graham Day to move the motion?
Move, Presiding Officer. Thank
you very much. No member has indicated they wish to speak against the motion. The question, therefore, is that motion 24394 be agreed. Are we agreed? Yes. We are agreed. The next item is consideration, Stage 3 proceedings of the Domestic Abuse Protection Bill. Members should have with them the bill is amended at Stage 2, the marshalled list, the groupings, and I would remind members that, as usual, we'll call a division bell and there'll be a 5-minute suspension for the first vote of the afternoon. Each vote will last 1 minute, and members who wish to speak in any group should press their request to speak button as soon as I call the group. So we're going to move straight to the marshalled list and Group 1, Domestic Abuse Protection Orders and Notices, places where Person A and Person B cohabit. Can I call Amendment 1 in the name of the Cabinet Secretary, grouped with Amendment 2, 3, 4, 5 and 6? Cabinet Secretary Hamza Youssef to move Amendment 1 and speak to all amendments in the group.
Thank you, Presiding Officer. I will speak to Amendment 1 and the other amendments in this group. At Stage 2, amendments were made to the bill to introduce a requirement that for the police to make a DAPN or for the court to make a DAPO, Person A and Person B must live together, some or all of the time. These amendments address concerns raised by the police about the potential width of the power to make DAPNs and DAPOs. It addressed these concerns by explicitly restricting the use of the power to cases where a suspected perpetrator of domestic abuse and the person at risk of domestic abuse live together. Excuse me. This approach was adopted because it is in such cases that a person at risk is most likely to benefit from the breathing space that a DAPN or a DAPO provide to take longer-term steps necessary to address their safety and their housing situation without interference from an abusive partner or indeed an ex-partner. We consider that a possible unintended consequence of these amendments to Section 1 is that there is a risk it could read as requiring Person A to live with Person B in Person B's home. Our policy intent is not that, and instead that a DAPN and DAPO should be able to be made regardless of where Person A and Person B live together. For example, if Person B lives with Person A in Person A's only home 3 days a week and in their own home for the rest of the week, but Person A has keys and regular access to Person B's home, it may be necessary to make a DAPN or indeed a DAPO that requires Person A, the suspected perpetrator, to surrender the keys to Person B, the person at risk, their home, and prohibits them from entering or coming within a certain distance of that home. Amendment 1 makes clear that a DAPN or DAPO can be made if Person A and Person B live together in any place where either of them live to any extent. Amendments 2 to 6 are intended to ensure consistency in the drafting to avoid any possible confusion in relation to which of the places where Person B lives is the home of Person B, when the focus should be whether it's necessary to make provision in respect to any of the places where Person B lives. I know that is somewhat complex and complicated, particularly if people haven't been following the legislation, but I hope that does clarify, because these amendments make it clear that in a case where Person B, the person potentially at risk, lives in more than one place, these provisions can be made in respect of any or more than one of those places, providing, of course, that such a provision is necessary. I should make it clear that provisions can only be made in a DAPN, a Domestic Abuse Protection Notice, if the senior constable who makes the notice considers it's necessary for the purpose of protecting the person at risk from such abusive behaviour by the suspected perpetrator. As such, where the person at risk sometimes lives at their own home and sometimes at their partner or ex-partner's home, I expect it would normally be necessary to use the power to prohibit their partner or ex-partner from entering both their own home and their partner or ex-partner's home. And in that vein, I move Amendment 1 in my name.
Thank you very much, Cabinet Secretary. And no other member wishes to make a contribution. Therefore, unless the Cabinet Secretary wishes to add anything, we'll move straight to the question. The question is that Amendment 1 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendments 2, 3, 4, 5 and 6 and invite the Cabinet Secretary to move them on block?
Moved on block.
Thank you. Does any member object if I put questions 2 to 6 on block? No. Thank you. The question is that amendments 2 to 6 are agreed to. Are we all agreed? Yes. We are agreed. Thank you. Turning now to Group 2. This is on domestic abuse protection orders, consent and matters to be taken into account by Sheriff. Can I call Amendment 9 in the name of the Cabinet Secretary, grouped with amendments as shown? Cabinet Secretary to move Amendment 9 and speak to all the other amendments in this group.
Thank you, Presiding Officer. I'll speak to Amendment 9 and the other amendments in this group. And if you'll forgive me, I will take a bit of time to explain how we've arrived at the position we've arrived at. And of course, with your indulgence, Presiding Officer, given the nature of how we've arrived at this point, if members wish to intervene, of course, I'll be happy to take interventions as well. At Stage 2, amendments were introduced that require the consent of a person at risk before a domestic abuse protection order, a DAPO, can be made. It was, as I said at Stage 2, a very finely balanced decision for the Scottish Government to lodge those amendments. And after further reflection, I've now lodged Amendments 9, 10 and 11 to remove the requirement for consent from the person at risk before a full DAPO can be opposed, and replace it with a provision that requires the court to take into account any views of the person at risk as to whether or not they wish an order to be made when assessing whether to make a DAPO. But it does not, and this is crucial, does not require consent. Amendments 12, 13 and 14 provide that where person B does not wish an order to be made, the Sheriff must take this into account and any of the reasons for that view of which the Sheriff is aware. However, Amendment 11 makes clear that a lack of consent would not stop a DAPO from being opposed if the court is satisfied that a DAPO should be made, having applied the relevant tests in Section 8 of the Bill. Amendments 15, 16, 17, 18 and 19 amend Section 12, 13 and 14 of the Bill to ensure a consistent approach is taken where an application of variation, extension or discharge of a DAPO is made to a court. So the overall effect of these amendments is that the court, in assessing an application for a DAPO, is required to take into account the views of person B, the person at risk, and the reasons for those views. But the need for consent is not a requirement, i.e. withholding consent is not effectively a veto on a DAPO being imposed. These views could be provided either directly to the court or indirectly, for example, through a support agency. And considering whether to make a DAPO in a case where person B does not support the making of the order, the Sheriff could take account of the extent to which person B's reasons for not supporting the making of the order are likely to be a consequence of the long-term effects of that abuse, and especially coercive and controlling behaviour can have on the victim of domestic abuse. So I want to explain briefly why I've adjusted my views in this very sensitive area of the bill. In many cases, it may be the views offered by person B do inform a decision that no DAPO is to be imposed, but I now consider that this has to be for the court to determine on a case-by-case basis. Having reflected on this very carefully ahead of Stage 3, I believe ensuring this discretion for the court is really the only way the fundamental purpose of the scheme of DAPOs can be delivered in each and every relevant case, which will enable the state to meet its responsibility to protect people at risk. The amendments I lodged at Stage 2 have been informed by discussions with Scottish Women's Aid, who reiterated their view, and I think they've reiterated again in a briefing sent to MSPs, that it is important to ensure that the process for making a DAPO does respect person B's autonomy and their right to make their own decisions about their safety. Furthermore, the Scottish Government has also had practical concerns in that it's unclear how effective a DAPO could be where person B does not support it being made. However, the question was and still remains how far we want the bill to go in this area. As I said when I was speaking at Stage 2, I've always considered the arguments for and against providing for an absolute requirement for consent to be very finely balanced indeed. While we remain of the view that one of the benefits of the system of the DAPO is to enable people who are experiencing domestic abuse to become more empowered, we've concluded that an absolute requirement for consent, leaving no discretion whatsoever to the court, would unduly curtail the ability and indeed the obligations on the state to fulfil their responsibility to protect those at risk of domestic abuse. In reaching this view, I've considered the European Convention on Human Rights, which imposes, and this is crucial, a positive obligation on the state to protect individuals from each other. The state has a positive obligation to take appropriate steps to protect vulnerable people, that includes women and children, affected by domestic abuse from threats which pose a risk to their lives. Their right to be free from inhumane, and degrading treatment, and their physical integrity. Significantly, for the purposes of the present issue, the European Court of Human Rights has specifically held that states need to put in place legal regimes which permit proceedings to be brought even where allegations have been withdrawn. So it's important to remember that in order to make a DAPO, the sheriff will have to have been satisfied of the tests in the bill. They are that person A, the suspected perpetrator, has engaged in behaviour which is abusive of person B, the person at risk. Secondly, there is an immediate or imminent risk of person A engaging in further abusive behaviour of person B. And thirdly, it is necessary to therefore make the order for the purposes of protecting person B from the abusive behaviour of person A. So retaining... of course I will.
Liam Kerr.
Yeah, I'm very grateful. I'm grateful for the articulation of the point, which I'm following with interest. I'm just slightly struggling with the Cabinet Secretary amended in consent at stage 2 and is now amending out consent in response, according to the letter of the 15th of March, as a result of legal advice saying it's got to comply with the ECHR. Now, I get that, but what has changed between stage 2 and stage 3? Was there not that legal advice at stage 2, or did the legal advice change in some way?
So, Mem will be aware I can't directly reference legal advice, and I was quite careful in my letter to him and to the committee around that. It simply is just further reflection. We had a discussion at stage 2 or pre-stage 2 with Scottish Women's Aid. We were persuaded by their concerns around consent and empowerment, I think, like the committee probably were. But on further deliberation, and he knows, of course, this bill has been in an expedited and truncated timetable for no fault, I don't think, of anybody in this chamber, that on further reflection, we feel that we had gone too far. And this example that I'm about to give, I think, is quite important, because what you could have is a situation where the sheriff believes that all the tests have been met. So a person B is at imminent risk of danger from a suspected perpetrator. That is therefore necessary to make the order. But even though they are absolutely sure about that, the sheriff is absolutely convinced about the immediate or imminent risk, regardless, they could not impose a DAPO if consent was withheld. And that is the concern I have, that if a perpetrator of abuse knows that an effective veto to a full DAPO being applied could be exercised by the person at risk, then they may, through coercive control, attempt to engineer an outcome. All I can say to Liam Kerr is that upon further reflection between stage 2 and 3, it became apparent that the state and the obligation that the state has to protect a person at risk, and if that was in conflict with a person's consent, then we got the balance wrong at stage 2, and therefore we have to rectify it at stage 3 through these amendments. We've also considered not just the European Convention on Human Rights, we've considered the Istanbul Convention, in particular Article 52. We consider the policy of the amendments I've lodged at stage 3 reflects the fundamental purpose of the scheme of the DAPO, which is based on the Istanbul Convention. Article 52 does not contain any requirements in respect to consent, but it does entirely focus on the state being able to protect those at risk. So, as I've said, and I'll conclude on this point, forgive me, Presiding Officer, for taking my time on this, it was an important grouping. The question of how the law should balance the autonomy of a person at risk of domestic abuse to make their own decisions, while at the same time providing protection for vulnerable people at risk of domestic abuse, especially in a case where that very autonomy has been compromised by coercive control, maybe years of abuse, that is a finely balanced question. However, I consider these amendments strike the appropriate balance and importantly take into account the state's duties and indeed obligations to protect people at risk of harm, and I move Amendment 9 in my name.
Thank you very much, Cabinet Secretary. Can I call John Finney to be followed by Rhoda Grant?
Thank you very much indeed, Presiding Officer. And can I say at the outset, declare my membership of the cross-party group on men's violence against women and children. And that's relevant because I have a measure of discomfort with what I'm going to say. Because the only time I can recall, I'm going to take a different point of view from Scottish Women's Aid, for whom I have the highest regard. I'll try not to repeat the detailed points that the Cabinet Secretary made, but with your indulgence, I would like to explain why that's the case. I most certainly want women to be in control, and there was an ongoing debate about the issue of consent. Now, Scottish Women's Aid say, and I accept this point, and I quote here, the problem with issuing orders without women's consent is that non-consensual intervention further disempowers. I get that, absolutely get that. And much of what I was going to say was contained in the Cabinet Secretary's letter to the Justice Committee of the 15th of March. And it is around the issues of, I think the Cabinet Secretary referred to it as test, but the threshold that would have to be overcome to secure the issuing of a domestic abuse protection order. And I'll not repeat these. The Sheriff has to be satisfied that that threshold is reached. Controlling and coercive behaviour, and that's something that we legislated for in the Parliament, I think, in a world-leading way in recent years. That's an invidious way that women are manipulated, and that's often at the back of my mind when we discuss these matters. There are women who are not quite at the point of reaching out for help, for trusting others, whoever these others might be. And I think when the Cabinet Secretary uses the term "our considered view," that's the reflection I've had. And I say, again, I note everything that Scottish Women's Aid have said in their briefing to us, and absolutely empowerment of women is important. It's a very fine principle that ordinarily I would accept unquestioningly. Of course, the legislation isn't exclusively about women. Overwhelmingly, the victims of domestic violence are women. But if the Sheriff is granted, is satisfied that that high threshold has been reached, and the victim's consent isn't forthcoming because of controlling and coercive behaviour that can sometimes take a number of years to emerge, and that victim was subsequently harmed, then that would trouble me. And if it's one person that's harmed, it's one too many. So I continue to support the principle of empowerment. I have changed my position in this. I think the Scottish Government have laid out the rationale, and it's for them to explain their obligations in terms of the state. The concern I would have that if one victim was created as a result of the existing arrangements, then that would be one too many. So I will be supporting the amendments in this group. Thank you very much.
Thank you very much, Mr Finney. Can I call Rhoda Grant?
Thank you, Presiding Officer. I'm not going to repeat what others have said. I think we need to note that at the time of our relationship breakdown, and in a way, the domestic abuse protection orders and notice bring forward the breakdown of a relationship by separating a couple. That is the most dangerous time for a victim of domestic abuse, because that is when most murders happen in that situation. So we must take every step we can to protect victims of domestic abuse. But we also need to remember those victims have had their agency removed for many years. And the way we do that is not to double down on moving that agency. That said, I believe that there are safeguards in the legislation to allow that to happen without destroying a victim's agency. And I would just seek some reassurance from the Cabinet Secretary that he would be clear that there would be training for sheriffs. Not all sheriffs understand domestic abuse well. And in order for them to carry out this work, they really need to have a deep understanding of domestic abuse. They need to be able to take the views of the victim without undermining them further. So that the training needs to be in place to make sure that this can be carried out in a way that the victim feels listened to, feels understood, and understands perfectly why a sheriff might be taking action would be contrary to their own view. They are open to coercion at this point, of course they are, and if the perpetrator of the abuse knew that they could stop the domestic abuse protection order actually going through, then that may leave them in a more vulnerable position. But we have to make sure that their agency is further destroyed. Those reassurances from the Cabinet Secretary.
Thank you very much, Ms Grant. And can I call the Cabinet Secretary to wind up in this group?
Thank you, Presiding Officer. Can I thank both John Finney and Rhoda Grant for making exceptionally important points on the record and for the reassurances that they seek, which hopefully I'll be able to provide. In terms of John Finney's remarks, I associate myself with him entirely. I generally feel uncomfortable when it comes to taking a different view from Scottish Women's Aid on any issue, frankly, but particularly on issues in relation to domestic abuse. I spoke to Marsha Scott, the CEO of Scottish Women's Aid this morning, and we agreed in some respects. To an extent to disagree. I think her feeling, and Marsha Scott can articulate herself much better than I'll be able to paraphrase for her, but certainly her feeling was that perhaps she wasn't quite as convinced as we were about the obligations on the state and getting that balance right. However, she recognised, I think, that if that is the advice we are being given, then effectively we have no choice but to bring forward these amendments that we have brought forward. What I would say is to John Finney and the points that he raised, I also, of course, have to ensure as a government minister that any legislation that I'm bringing forward is compatible with ECHR. Indeed, this Parliament has that obligation, but I also have that obligation, hence why I brought these amendments forward. In giving reassurance to Rhoda Grant on the points that she raises and articulates well, on her first point, the bill makes it really clear, very clear, about the fact that sheriffs must take the views into account of the person at risk. I detailed that in some of my remarks earlier. She makes a very good point about judicial training. I should say that is not my gift. Judicial training is in the gift of the Lord President, who exercises that function independently. However, if this bill, when this bill, I hope, passes stage 3, it is certainly a discussion I'm happy to take forward with the Lord President, and the fact that we're going into a pre-election period. I'll ask my officials to do that during the pre-election period, but dependent on election results, I would hope that whoever is in the post of Justice Secretary would follow that up with sheriffs. So I think John Finney and Rhoda Grant makes excellent points. I'm pleased that on balance, I think everybody understands why we've got to the position we've got to, and I think it is the right position to get to, that the state can then fulfil its obligation of protecting people at risk of harm.
Thank you very much, Cabinet Secretary. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendments 10, 11, 12, 13, 14, 15, 16, 17, 18 and 19 and invite the Cabinet Secretary to move the amendments on block?
Moved on block.
Thank you. Does any member object if I put the questions 10 to 19 on block? No. Thank you. The question is that Amendments 10 to 19 are agreed to. Are we all agreed? Yes. We are agreed. Thank you very much. I turn now to Group 3. This is on domestic abuse protection orders, power to specify additional applicants. Can I call Amendment 20 in the name of Liam Kerr in a group on its own? Liam Kerr to move and speak to Amendment 20.
Thank you, Presiding Officer. Amendment 20 in my name provides the Scottish Ministers with a power to designate other bodies as being able to apply to a court for a domestic abuse protection order. Now, this was something I initially sought to introduce at stage 2, and while support for the principle was indicated by both the Cabinet Secretary and Rhoda Grant, then Justice Spokesperson for Labour, I was persuaded by the Cabinet Secretary that such regulation-making power should be future-proofed. And it was also pointed out that, given the importance and the issues that have to be considered, it would be better for this procedure to be affirmative rather than negative, to give Parliament a greater chance to scrutinise and be reassured that any bodies that were being added were fully ready to take that responsibility when it comes to training, resources and all the other matters discussed previously. Now, I found this argument persuasive and withdrew my amendments on this point to work with the Cabinet Secretary and his team to produce something better. We did that, and I believe this has been achieved, and I'm very grateful to the Cabinet Secretary and his team for that. So at present, Presiding Officer, the bill empowers the police, but no other agency or organisation to apply for a DAPO. During the committee sessions, the idea of extending that power was raised, in particular by Scottish Women's Aid and Police Scotland. So this amendment specifically provides that local authority landlords and registered social landlords could be empowered to apply for DAPOs, as was suggested at stage 1 would be appropriate. Now, subsection 2D provides that it is for the Scottish ministers can then use this power to provide such other persons as the Scottish ministers consider appropriate with the power to apply to the court for a DAPO. Subsection 3 introduces a requirement to consult with those whom it is proposed be given that power prior to making the regulations. This is intended to ensure that those organisations whom it is proposed are given this power have an opportunity to provide views prior to the making of the regulations. And finally, subsection 5 ensures regulations made under this power will be subject to the affirmative procedure. In short, this is what I sought to achieve at stage 2 and what I think can properly be achieved now. I therefore commend my amendment to Parliament and move Amendment 20 in my name.
Thank you very much. Mr Kerr, can I call the Cabinet Secretary?
I can be very brief. Presiding Officer, I thank Liam Kerr for initially lodging the amendment at stage 2 and then agreeing to withdraw it and work with the government ahead of stage 3. I support absolutely what he's trying to do. He has articulated it very well and gone into the detail of the amendment, so I don't need to rehearse that. In my view, Amendment 20 appropriately future-proofs the legislation to allow other persons to be added to the list of those that can apply for a DAPO where appropriate to do so. I'm also pleased that the level of scrutiny has been strengthened, requiring affirmative procedure. I may be the first government minister in history to argue for more scrutiny of an order than the opposition have asked for, but is absolutely the right thing to do. This recognises the significance of the issues that have to be considered in making use of such a power, and will give Parliament a much greater chance to scrutinise and be reassured that any person the Scottish ministers may seek to give the ability to apply for a DAPO on behalf of a person at risk are suitably equipped and trained for such an important responsibility. So I thank Liam Kerr for the constructive manner in which he's engaged with the government, and we will be supporting Amendment 20 in his name.
Thank you very much. And does Mr Kerr wish to add anything by way of winding up?
Nothing to add, Presiding Officer.
Thank you. So we'll go straight to the vote. The question is that Amendment 20 be agreed to. Are we all agreed? Yes. We are agreed. Turning to Group 4, Domestic Abuse Protection Orders and Notices, Relationship with Orders Regulating Contact or Residence. Can I call Amendment 21 in the name of Rhoda Grant in a group on its own, and Rhoda Grant to move and speak to Amendment 21?
Thank you, Presiding Officer. I move Amendment 21. Domestic abuse protection notices and orders are designed as emergency interventions to protect people from domestic abuse, and we must ensure that that cannot be undermined. A number of organisations expressed concerns that the intention that domestic abuse protection notices and orders to precedence over all other orders was not expressed on the face of the bill, and felt that should be the case. This is especially the case with notices that are not required to be heard by a court. While I believe we should explicitly say on the face of the bill that all orders tying person A to their home are superseded by a notice or order, Cabinet Secretary did not believe that was required. However, he did concede that orders regarding children should be placed on the face of the bill. Therefore, subsection A of this amendment provides that nothing in a court order regulating contact or the residence of a child limits the prohibitions or requirements that can be made in a domestic abuse protection notice or order. Subsection B of the amendment provides that it is not a defence for breaching the domestic abuse protection notice or order that person A was doing something that they were entitled to do under another court order. It's very clear that the domestic abuse protection orders and notices must take precedence over any other order tying person A to the home, and in order to provide the protection that is required. Thank you, Presiding Officer.
Thank you very much, Ms Grant. There's no other colleague wishes to contribute. Can I call the Cabinet Secretary?
Thank you, Presiding Officer. At stage 2, Ms Grant brought forward an amendment intended to make clear the provisions of a DAPN and that they must be complied with irrespective of any pre-existing court order that may be made with a contrary provision. I was happy in principle for the bill to make it clear that those who have a DAPN served on them are absolutely no doubt whatsoever that the existence of perhaps a pre-existing child contact order did not mean that the DAPN could not make provisions prohibiting contact with that child. However, I indicated, as Ms Grant has suggested, that there were some technical concerns I had around that amendment. I'm pleased to say I consider Amendment 21 very much addresses those concerns. It makes it clear that the existence of a court order regulating contact with or residence of a child does not limit the requirements or prohibitions that can be included in a DAPN or a DAPO. So, for example, if a person subject to a DAPN or DAPO, which prohibits them from contacting a child, contacts that child, it would not be a defence that they were acting in accordance with an entitlement in a child contact order. So I welcome Amendment 21. Thank Rhoda Grant for the constructive way in which she's worked with the government on it, and I'll be supporting it.
Thank you very much. Does Ms Grant wish to add anything by way of winding up?
No, nothing more to add.
Thank you very much. So the question is that Amendment 21 be agreed to. Are we all agreed? Yes. We are agreed. Can I turn to Group 5, reporting on operation of Part 1. Call Amendment 22 in the name of Liam Kerr in a group on its own. Liam Kerr to move and speak to Amendment 22.
Thank you, Presiding Officer. Amendment 22 in my name is about reporting on the operation of Part 1 and introduces a reporting requirement for the Scottish Ministers to examine and monitor the number of domestic abuse protection notices and orders that are made, the number of offences for breaches that are reported and the number of convictions obtained. Now again, this was something I brought forward at stage 2 as I was concerned at the lack of such a duty, particularly given that there is such a duty under Section 14 of the Domestic Abuse Act of 2018. And also, both Scottish Women's Aid and the Law Society indicated general favour towards this sort of monitoring. Now again, the Cabinet Secretary indicated he was sympathetic to the principle of information and data being available about the operation and new powers in the bill to help inform Parliament and the Government when it comes to future policy, and of course it will help them to assess the effectiveness of the bill. Again, however, the Cabinet Secretary suggested not moving the original amendment with a view to developing what I proposed to make it as good as it can be and ensure that we're capturing both what is necessary but also what is useful. And of course, that the criminal justice agencies are capable of providing that data. So Amendment 22, therefore, provides for a reporting requirement for the DAPN and DAPO scheme. It requires information on the number of DAPNs, DAPOs and interim DAPOs made to be reported, and for information to be reported about the number of extensions made to DAPOs. It also requires information to be reported on the number of prosecutions and convictions for offences of breach of a DAPN or a DAPO. There is also the addition of a requirement to include information about the experience of persons who are, in respect of a domestic abuse protection notice, order or interim order, person B. All of which will place a duty on the Scottish Ministers to undertake work to establish the extent to which the system of DAPNs and DAPOs is effective in achieving its purpose of protecting persons at risk of domestic abuse. The amendment places the duty to report on the operation of the Act during the first 3 years in which it is in effect. And finally, MSPs will be interested to note this amendment has been shared with Scottish Women's Aid in light of their interest in this matter, and they have indicated they are content with it. And therefore, I move Amendment 22 in my name.
Thank you very much, Mr Kerr. And can I call on the Cabinet Secretary?
Thank you, get my words out. Thank you, Presiding Officer. I can also be brief. I once again thank Liam Kerr for the constructive manner in which he's engaged with the government. I think we've got the balance right between quantitative data and qualitative data. I think it's really important. We've got that in the amendment. I think it's really, really important for us to be able to understand the qualitative experiences from victims of domestic abuse. So I think this reporting mechanism, which has become more common in legislation actually in recent years, is to be welcomed. So I welcome the amendment in Liam Kerr's name, the amendment number 22, and the government will be supporting it.
Thank you very much, Cabinet Secretary. Does Mr Kerr wish to add anything?
No.
We'll go straight to the question. The question is that Amendment 22 be agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 6, guidance on certain matters connected with tenancy proceedings in cases involving domestic abuse. Can I call Amendment 7 in the name of the Cabinet Secretary, grouped with Amendment 8, Cabinet Secretary to move Amendment 7 and speak to both amendments?
Thank you, Presiding Officer. I'll speak to Amendment 7 and 8. These amendments provide for Scottish Ministers to make guidance in relation to the changes introduced by Section 18 of the Bill and to consult such persons as they consider appropriate in the development of guidance. They also place a duty on social landlords to have regard to any statutory guidance published by Scottish Ministers on the new power for recovery of possession or termination of a joint tenant's interest in a Scottish secure tenancy set out in Section 18 of the Bill. Amendment 7 amends an existing section in the Housing Scotland Act 2001 about statutory guidance to expand its remit to include cases where the new tenancy repossession or termination grounds are used. Amendment 8 separately provides for guidance in respect of the new provisions introduced in the 2001 Act at Section 14, subsection 5C, which provides that the landlords must provide advice and assistance to the perpetrator and any qualifying occupier in relation to the finding of alternative accommodation. We brought forward these amendments to support social landlords in using the provisions, and we will develop statutory guidance in consultation with key stakeholders in advance of bringing the provisions at Section 18 into force. The guidance will cover a wide range of issues and positive practical examples, such as the type and the level of evidence landlords should consider before deciding to use the provisions, dealing with matters such as rent arrears, the types of advice and assistance provided to perpetrators, and therefore I move Amendment 7 in my name.
Thank you very much, Cabinet Secretary. And no other member wishes to contribute, so we'll go straight to the question. The question is that Amendment 7 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 8, Cabinet Secretary, to move?
Moved.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 7. This is on the provision of tenancy following termination of tenancy or interest in tenancy in cases involving domestic abuse. Can I call Amendment 23 in the name of Rhoda Grant, grouped with Amendment 24? Rhoda Grant to move Amendment 23 and speak to both amendments.
Thank you, Presiding Officer. I move Amendment 23 and speak to Amendments 23 and 24. In cases with domestic abuse, it is often the abuse survivor, that has to flee their home and find alternative accommodation in a refuge or even in homeless accommodation. And that's often why the victim returns to their abuser, because living in a refuge, it might provide safety, but it's restrictive both in space and freedoms, and homeless accommodation can be absolutely grim. And this is especially the case if children are involved. The survivor may feel that it is in their best interest to return home due to their living conditions. The bill therefore endeavours to deal with this by trying to remove the abuser and allow the survivor to remain in their home. It raises issues with tenancies and whether they are joint tenancies or solely in the name of the abuser. My amendments seek in different ways to ensure that the survivor remains in the tenancy and becomes the legal tenant if that is their wish. Amendment 23 has the effect of the tenancy passing to the abuse survivor automatically on the date which is contained in the eviction order issued by the court, ending the tenancy of the abuser. This would ensure that the tenancy arrangement continued, but in the sole name of the survivor, regardless of whether or not they were party to the original tenancy agreement. Amendment 24 allows for a new tenancy to be created, and this will be in the case where there are rent arrears. It allows the survivor a fresh start, recognising that financial control is part of domestic abuse. It allows 28 days for this to happen, but stresses that it should be as soon as practicable. This might be required if an abuser has remained in the tenancy, and it may be that the property needs to have repairs and safety checks carried out before the survivor can safely take occupancy of the property. This amendment also makes an exception to the duty in the very rare circumstances where it might not be possible or appropriate for the landlord to offer the tenancy to the survivor. And this might be if, for example, they were unable to locate them because they had gone off the radar because they were afraid of being tracked down by the abuser. And it might also be that they were unsuitable for the tenancy for another reason. And this could create a loophole if the amendment allows Scottish ministers to issue guidance on what those exceptional circumstances might be in order to avoid creating that loophole. This guidance must also include when the tenancy is deemed to be a continuation or when it should be a new tenancy in its own right. Where possible, it should be a continuation, but where there are rent arrears, but they must be shared, and the abuser cannot simply walk away and leave the survivor to deal with those rent arrears. In this situation, it would be desirable to start a new tenancy. This guidance must be clear, and that there are often behaviours attached to domestic abuse that might be antisocial and might include rent arrears, drug or alcohol misuse and noise complaints and so on. The guidance to landlords must ensure that they're aware of these issues and should not use them as a way of entering into a tenancy with the survivor in order that the survivor can be supported to continue in that tenancy. Thank you, Presiding Officer.
Thank you very much, Ms Grant. I could invite the Cabinet Secretary to respond.
Thank you, Presiding Officer. I'll speak to Amendments 23 and 24, and I thank Rhoda Grant for her articulations of the reasons why she's lodged those amendments. I think I'll speak first in terms of Amendment 24, because we intend to support Amendment 24, but not Amendment 23, and hopefully my explanation of 24 will provide the Chamber with the reasons of why we cannot support Amendment 23. Again, I thank Rhoda Grant for working closely with the Government on Amendment 24, which, as I say, we will support. Amendment 24, as Rhoda Grant has articulated, places a legal requirement on social landlords to offer the tenancy of the family home to the victim within 28 days of the perpetrator being evicted on grounds of domestic abuse. The amendment does not go so far as to require the tenancy to take effect from a particular date. Rather, this provides landlords with the flexibility to deal with cases where, for example, the perpetrator has remained in the family home prior to the eviction, and then the landlord has to carry out essential repairs, perhaps legal safety checks, prior to any victim moving in. This will provide further reassurance to victims that they will be offered the tenancy of the home where a perpetrator is evicted on the grounds of domestic abuse. Amendment 24 goes on to relieve landlords of the duty to offer the tenancy if there are exceptional circumstances where this is not possible or indeed appropriate. An example of this may be if the landlord was unable to locate the victim to make the offer of the tenancy to them. We anticipate that such cases would obviously, hopefully, be very rare, but we have made the provision for an exemption to the duty to make the offer so that it is not absolute. The amendment also requires landlord to have regard to any guidance issued by the Scottish Ministers about all of these matters. Turning to Amendment 23, I do understand the intention behind Amendment 23 and understand that is in the case of a joint tenancy to create a new tenancy upon the termination of the perpetrator's interest in the property, with a view to preventing the victim becoming solely responsible for any rent arrears accrued during the course of the joint tenancy with the perpetrator. So I think all of us would recognise the very good intentions being sought here, but there are some key deficiencies and what I would describe as adverse unintended consequences of this approach. Firstly, the amendment does not in fact provide for the creation of a new tenancy. Rather, it states that the tenancy would, and I quote, pass in law to the victim, meaning the existing tenancy would pass to the sole tenant. So even if the amendment did allow for this, the landlord would still have the ability to pursue all or any former joint tenants for rent arrears should they wish to do so. The amendment would not actually prevent this. Furthermore, Rhoda Grant's amendment does not work in all cases, and this is the unintended consequence. It does not take into account situations where there may be more than two joint tenants. In such a case, the amendment would have the, I would say, unintended consequence and unfortunate consequence of transferring the whole tenancy, not just the interest of the abuser, to the victim of the abuse. So let's give an example. There could be two people, two friends who live together as joint tenants. One of them forms a relationship with another person. That person becomes the third joint tenant. If abuse is perpetrated, the effect of Amendment 23 could be to remove a person's legitimate tenancy right as the tenancy would transfer to the victim of the abuse, and therefore the friend of the victim of the abuse would have their tenancy interest removed. Although I'm absolutely sure this is not what Rhoda Grant is seeking, that would be the unintended consequence of the amendment. In terms of seeking to achieve the aim sought by Rhoda Grant, I would note that the primary aspects of the legislative changes we introduce here are to help ensure tenancy sustainability and for landlords to provide ongoing support to victims of domestic abuse, both by being able to proactively pursue tenancy transfers and allow a victim to remain in their family home, and providing any support and assistance required, including managing rent arrears. As part of that, landlords will need to follow existing pre-action requirements. It is the government's intention to amend these to make it a legal duty to take into account the effect domestic abuse has on the accrual of rent arrears. For all these reasons, I cannot support Amendment 23. I would urge Rhoda Grant to withdraw them, but if she does not, I would urge other members to reject them. And on the other hand, I support Amendment 24 and invite other members to do so.
Thank you very much, Cabinet Secretary. Can I ask Rhoda Grant to wind up in this section and to press or withdraw Amendment 23?
Thank you, Presiding Officer. Amendment 23 and 24 work together, so I think they provide a range of options for victims. I think it's important that where a victim desires, then the tenancy should continue, because this gives them security, especially in financial matters, to show that they have lived at an address for a length of time. So the two different options allow for the situations the Cabinet Secretary has talked about, and I believe work well jointly. Amendment 23 removes the interest of the perpetrator and transfers that to the victim without forming a new tenancy, and I think that is really important. So I intend to press both amendments, because I believe together they provide a safety net regardless of the situation, providing the victim with options that they can work through with the landlord. So, Presiding Officer, I will press Amendment 23.
Thank you very much, Ms Grant. So moving to the question is that Amendment 23 be agreed to. Are we agreed? No. We're not agreed. So we'll move to a division. This is the first division of the afternoon, so we'll have a 5-minute suspension while I call members to the chamber and allow members online to access the voting app. A 5-minute suspension. Thank you, colleagues. We are now back in session and we're going to go straight to the vote. The question is that Amendment 23 be agreed to. So members may cast their votes now. This is Amendment 23 in the name of Rhoda Grant. A 1-minute division. That vote is now closed. Please let me know if you were not able to vote. And I'll call Graham Simpson to make a point of order.
Presiding officer, my screen, which I've just refreshed, didn't show a vote. It would have been no.
Thank you, Mr Simpson. You would have voted no. I'll make sure that vote is recorded. Thank you. The result of the vote on Amendment 23 in the name of Rhoda Grant is yes 24, no 95. There were no abstentions. The amendment is therefore not agreed. Can I call Amendment 24, Rhoda Grant, to move?
Moved.
Thank you very much, Ms Grant. The question is that Amendment 24 be agreed to. Are we all agreed? We are agreed, and that ends consideration of amendments. Now, as members may know, at this stage in proceedings, I am required under standing orders to decide whether or not, in my view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, the Domestic Abuse Protection Scotland Bill, it does not. Therefore, it does not require a supermajority to be passed at stage 3. So we're going to move on shortly to the debate. There will just be a short pause. Colleagues, we're just going to suspend for 5 minutes before moving on to the debate. A 5-minute suspension before we move on to the debate on the Domestic Abuse Bill.
Hello again, everyone. Next item of business is a debate on motion 24381 in the name of Ash Denham on Domestic Abuse Protection Scotland Bill. Can I invite those members who wish to speak in the debate to press the request to speak buttons? And I call on Hamza Yousaf to speak to and move the motion for up to 7 minutes. Please, Cabinet Secretary.
Thank you very much, Presiding Officer. I would like to open this debate, as is customary, by thanking all of those who have worked hard to get us to this place and get this bill into shape for stage 3. Let me thank, first of all, my own bill team, who have not had their challenges to seek in terms of legislation in a very truncated timetable as well. They have worked extraordinarily hard and worked with members right across this chamber in terms of amendments brought forward at stage 3. Let me also thank members and clerks of the Justice Committee for their scrutiny, for their diligence, and again for working constructively with the government when it's come to a number of amendments here at stage 3. And can I also thank, crucially, those who have taken their time to share their knowledge, their experiences during their scrutiny process. Scottish Women's Aid have been referenced, but I know there's many other organisations such as Assist, but also many survivors and victims, predominantly women, who have come forward to speak of their experiences of domestic abuse. And I think, I'm certain, in fact, I can speak for everybody in this chamber, that we applaud their bravery. Presiding Officer, these are not normal times, and the pressures facing many of us as a result of the coronavirus pandemic have meant that we've struggled to dedicate the time to help Parliament to develop new laws, as I say, as there have been other competing priorities. So I'd really like to thank members for the time that they've given to this bill, because I think it is absolutely crucial. So in a week where this Parliament has united already to incorporate the UNCRC into domestic law, here's another opportunity for us to unite around transformational legislation. The pandemic has meant, of course, that we're all spending more time in our homes, and that will be welcome for a lot of people. I certainly have enjoyed that time that I've spent with my family at home. But sadly, we know that is not true for everybody. The scourge of domestic abuse remains a blight in Scotland. Earlier in this parliamentary session, when hearing evidence on what is now the Domestic Abuse Scotland Act 2018, we heard harrowing examples of the kind of behaviour that perpetrators of domestic abuse may engage in. We now better understand the totality of what it is like to experience domestic abuse. Yes, of course, it can be physical, we know that, and we've known that for a long time. But also we know it can be behaviour that is intended to humiliate, to denigrate a partner, and to exert control over every aspect of that individual's lives. It is corrosive, coercive, controlling behaviour. While the new domestic abuse offence has improved the criminal justice system's ability to take action against perpetrators of abuse, we know that we cannot rely solely on the criminal justice system alone to deal with domestic abuse. Inevitably, there are cases where there will not be the required evidence to proceed with a criminal prosecution and therefore unlock the criminal court powers that can protect those who are at risk. When someone is being abused by a partner or ex-partner with whom they live, and it is not possible to take criminal action against their abuser, they may lack the freedom of action to pursue, for example, civil court action, and can find that they have very, very few options. We know that domestic abuse is the leading cause of homelessness for women, and it's easy to see why this is the case. I suspect I'm not the only MSP who has had to deal with such cases on a far too regular basis. If this bill is passed by Parliament today, it will provide new powers that can be used to protect people, predominantly women. Of course I will.
Liam Kerr.
It'll be very brief. Just on the, you were talking about the statistics there and the homelessness and things. I was looking earlier at the Scottish Government's forthcoming publications. I might be missing something, but I don't see the usual publication of the Scottish Government's domestic abuse statistics. Now, last year, I think they were published on the 25th of February. So are they going to be published, and if so, when?
Hamza Yousaf.
Forgive me, I will take a look at that since the member has raised it, and I will get back to him before this Parliament rises in the next few days. Presiding Officer, the powers that are provided in this bill are significant. Part 1 of the bill creates new powers for the police and the courts to make a domestic abuse protection notice or indeed domestic abuse protection order when it comes to the courts. That can remove a suspected, and that is an important word, a suspected perpetrator of domestic abuse from the home of the person at risk. and prohibit them from approaching or contacting the person at risk or indeed any children involved. This provides the police and the courts with powers to take action to remove a suspected perpetrator of abuse from a home they share with a person at risk for a period of up to 3 months. This is intended to protect the people living with an abusive partner or ex-partner, and again gives them that breathing space within which they can decide to consider their longer-term steps that they can take in relation to address their safety and their housing situation without any interference from their abuser. Part 2 of the bill makes provision to enable social landlords to transfer a tenancy to a victim of domestic abuse. As it stands, there are a number of grounds on which a landlord can evict a tenant and reassign the tenancy to another person, but domestic abuse is not one of them. So a new ground on which a social landlord can apply for a court order to end the tenancy of the perpetrator is being created. This would allow the victim to remain in the family home as sole tenant. Having the legal ability to end a perpetrator's tenancy in domestic abuse cases will allow social landlords, without requiring the victim to commence this process themselves, to take a more proactive role in supporting and protecting victims of domestic abuse and support the victim to remain permanently in the family home. The bill has been subject to effective scrutiny through a timetable, which has meant that the bill has moved quickly from stage 1 just 2 months ago in January to today, stage 3 proceedings and indeed debate. I know this has been challenging, and I thank the excellent work of the Justice Committee in progressing scrutiny alongside the many other demands that have been placed upon them. Presiding Officer, this bill provides us with a legislative framework to implement a scheme of protective orders for people at risk of domestic abuse. However, I'm all too aware that this scheme is to be effective in actually improving the lives of those people experiencing domestic abuse. How it is implemented will be vitally important. Indeed, I would observe that a number of the concerns that were raised during the parliamentary scrutiny of the bill did not relate to the exact wording of the provision, but how it will be implemented in practice. As I said at the stage 1 debate, there will be a Scottish Government-led implementation board that will bring together all the key interests and stakeholders and partners, including Police Scotland, Scottish Courts and Tribunal Service, Scottish Women's Aid, and others, to work together to put in place the necessary processes to ensure that protection can be effectively that protection can effectively be given to those who are at risk of domestic abuse. To conclude, Presiding Officer, legislation alone, we know, cannot address the issue of domestic abuse. However, ensuring appropriate powers are available through this legislation does have a key role to play. The bill will, once implemented, provide our police, our courts and social landlords with significant new powers to deal with domestic abuse. Use of these powers will reduce the risk that the only way a person can escape an abusive partner is to flee their own home, often having to take their children with them, or indeed, even in a worse situation, leaving their children behind, and then having to rely on emergency homelessness provision. That cannot be right. We collectively have a duty to ensure our law and our law enforcement agencies have the tools to prevent victims being faced with such an impossible and devastating choice, simply for their own safety. So we collectively have a duty to ensure our law can keep people safe in their own homes. I believe that this bill provides the law enforcement agencies with those tools and allows us to fulfil that collective duty. I move that the Parliament agrees the Domestic Abuse Scotland Bill be passed.
Colin Liam Kerr for 6 minutes, please.
Thank you, Presiding Officer, and I confirm that the Scottish Conservatives will vote in favour of the Domestic Abuse Protection Bill at decision time tonight. We share the Chamber's condemnation of domestic abuse as, to use the Cabinet Secretary's word, a scourge, correct word, on society, and we welcome any attempt to address it and get justice for victims. And the context within which we're considering this is sobering. Recorded incidents of domestic abuse have risen in Scotland over the past 3 years. Indeed, the number of domestic abuse charges were at a 4-year high in 2019-20. The committee heard evidence that every year Police Scotland is called out to around 60,000 incidents of domestic abuse. That's an average of 5,000 a month, 1,200 every week. And each incident they attend consumes on average 9 hours of police time. The social costs are massive, to say nothing of the horrific impact on the victims. This is terrifying, and we are united, I have no doubt, in our wish to try and address it. And this bill has 3 basic ways to try to address that. First of all, to protect a person at risk of domestic abuse in the immediate term by giving of a power on reasonable suspicion to a senior police officer to issue a domestic abuse protection notice on a person engaged in abusive behaviour. Breach of such notice is a criminal offence, and it operates to force a person to leave the home and stay away. Second, to set out provisions for the domestic abuse protection order. Wherever a DAPN is issued, the police must apply to the court for a DAPO on the first court day after the notice is issued, and any order can last up to 2 months, extendable to 3 months. Breach is a criminal offence. Now, I recall that I proposed an amendment to the bill that ultimately would become the Domestic Abuse Scotland Act of 2018, which called for something similar. So I'm very pleased this is present. And third, to give social landlords a new power to evict a tenant where the tenant is engaged in abusive behaviour. It is a good bill in its principles, and it's been further improved, as the Cabinet Secretary rightly said, at stage 2. For example, I flagged at stage 2 Police Scotland's representations that other statutory and third-party agencies should be able to apply for a DAPO. The police had pointed out that reliance on a single organisation, such as Police Scotland, to apply the legislation not only creates a significant and potentially unmanageable demand on a single service, but is out of step with the established partnership approach in Scotland. So I'm pleased that Parliament saw fit to pass my Amendment 20 today, which gives effect to this. But I made the point at stage 2 that ultimately it will be the practicalities of this bill that need to be addressed, because legal bodies and the police in particular had signalled outstanding issues that might mean its powers proving difficult to use in practice. As Detective Chief Superintendent McCluskey said, even at the moment, situations can be very challenging for officers on the ground. The Law Society flagged that DAPNs are to be imposed by Police Scotland, but note that exactly what will amount to a sufficiency of evidence, and indeed the quality of that evidence in relation to abusive behaviour, might not be consistent. And if there is that ambiguity, there is a risk of variations in use of the bill's provisions, depending on the operational decisions taken on a day-by-day and case-by-case basis by Police Scotland. Now, the Law Society argue that this leads to a risk that there could be inconsistent practices across Scotland, as well as a lack of certainty, all of which feeds into resources concerns. Scottish Women's Aid made this point forcefully and well in their briefing to us today. The police must be adequately resourced to respond appropriately when assessing and imposing DAPNs or dealing with DAPOs and on enforcement. That will need training, which requires money and it requires time. And they make clear it is not only the police, but education and training will be required for all involved, such as the judiciary, COPFS and specialist independent advocacy. Now, Cabinet Secretary referred in his opening remarks to the post-bill implementation group being set up to bring together all the key agencies affected by the new legislation, including Police Scotland. And that is welcome, but it's not going to be straightforward. They will, of course, be assisted by the report required by my amendment today, which will allow for scrutiny and evaluation. It will help to measure just exactly what and where use is being made of these measures. But also, in line with Scottish Women's Aid's recommendations, it will broaden its focus beyond criminal justice outcomes to collect a much wider range of data on those protected and their children. Presiding Officer, every effort possible must be taken to prevent domestic abuse. This bill is another attempt to address this vile problem in society. It seeks to provide victims of domestic abuse with the protection they need, and we are absolutely supportive of that. I do remark very gently that, looked at holistically, I do have a concern that the presumption against short-term sentences would mean that those who breach a DAPN or a DAPO are unlikely to go to prison. And I wonder whether the Cabinet Secretary will address that concern in his closing remarks, because that's something that's been highlighted to me as a weak point by, or a potential weak point by victims. So if he could address that in closing, I'd be grateful. Presiding Officer, the Scottish Conservatives will always stand up for the victims of crime, and that is why we are very pleased to support this bill at decision time tonight.
Call Neil Bibby now for up to 5 minutes, please.
Thank you, Presiding Officer. Like the Cabinet Secretary, I'd also like to thank all the people and organisations who have contributed to this bill. The shocking and brutal death of Sarah Everard has reminded us all of how vulnerable women are to violence and abuse from men. But as tragic and as sad as this horrific murder is, it should not blind us to the fact that for women who are abused, the vast majority of attacks are carried out by perpetrators who are known to and often related to the victim. I do recognise that not all victims of domestic abuse are female, but the harsh reality is the vast majority are. So I want to say this, that this short but welcome bill is not about women, it's overwhelmingly about men and men's behaviour towards women. Scottish Labour are clear we need a criminal justice system that protects women and all victims. And this bill is another small step in correcting the power imbalance and unfairness which has always existed. It's another small step in giving greater protection, security and support to all victims of domestic abuse. And it's another small step in declaring to perpetrators of domestic abuse that this behaviour will not be tolerated. Scottish Labour supports this bill. We agree that there is a need to enhance the protections for those at risk of domestic abuse, especially when the risk is from a perpetrator living in the same home. During the scrutiny of the Domestic Abuse Scotland Act 2018, the Justice Committee became aware that the law and court processes in Scotland did not provide adequate protections for victims in emergency situations. This bill aims to close these gaps. Scottish Labour believes there were issues with this bill as originally drafted, but I appreciate the positive way in which everyone has worked to make this bill a reality, and I thank the Cabinet Secretary for his willingness to listen to suggestions. It remains to be seen if this bill will be effective. The proof will be whether it's able to change the experience of those at risk of abuse. Scottish Labour believes there should be more protection for children who witness abuse in their homes, and we welcome the changes which emphasise the need to consider children's views. That's why my colleague Rhoda Grant has pursued this matter. Improvements have been made in this regard, but this is an issue that will require to be closely monitored. However, we know that legislation on domestic abuse will never achieve its aims unless it's enforced, and we've already discussed that today. It also needs wider society to change, and it needs Police Scotland to use all available powers to protect victims. Domestic abuse protection notices and domestic abuse protection orders are not insignificant measures, and I appreciate the pressures this could place on Police Scotland. But it's right that urgent and effective action is taken to give immediate respite to victims. Forcing a perpetrator to leave the home of the abused partner to stay away for 2 months or more is the right thing to do. I understand the sensitivities of whether or not a full protection order should require the consent of the victim. However, it's also important that protection notices and protection orders need to be effective and need to be used to protect victims, some of who may be under the coercive control of their abusers. My colleague Rhoda Grant also made important points earlier about training. Rhoda Grant also sought amendments to clarify that other court orders, for example, regarding child contact, cannot be used as a defence for a breach of protection orders or protection notices. I welcome that these amendments are passed and the assurances they will provide. I also hope that the Scottish Government will revert to the Parliament if evidence shows that the time limits for the protection orders are not sufficient. Finally, Presiding Officer, the Cabinet Secretary emphasised the importance of implementation. And like Liam Kerr, I am clear the age-old problem and question of resources needs to be confronted too. This legislation will place an additional burden on Police Scotland, the court service, the legal aid system and housing providers. I would not want to see the effectiveness of this legislation diminished through lack of proper investment, and I hope the Cabinet Secretary will give comfort to Parliament on this. In conclusion, Scottish Labour commends this bill. We hope that while it is short, it will be effective, and I look forward to making a positive difference to the victims of domestic abuse.
Thank you. And I call John Finney now, please, for 4 minutes.
Thank you very much indeed, Presiding Officer, and thanks to go to all the people who have brought us to this point. As my colleagues have said, many in number, and their contributions have all been very helpful in shaping this legislation, which at decision time tonight the Scottish Green Party will support. One of the early contributions, Presiding Officer, was a briefing from Spice, and they had a section called The Story So Far, and this outlined the changes that have taken place over a period of time. And that's an evolving story, and it's a story that hopefully is playing its part in addressing what the previous speaker, Neil Bibby, referred to as the power imbalance. I think we've a way to go, but chipping away at it is making some progress. And that was about the scrutiny of what's now the Domestic Abuse Scotland Act 2018, which saw members of the Justice Committee take very harrowing testimony from people about the circumstances they had found themselves in. I have to say, obviously they cannot be discussed in detail, but it would demolish a lot of the stereotyping that's assumed to be associated with this vile scourge of domestic violence. And it was about controlling and coercive behaviour. And this piece of legislation is rightly viewed as unfinished business, Presiding Officer, a gap in the requirements of the Istanbul Convention, which has been signed by the UK government but not yet ratified. Indeed, Scottish Women's Aid told us it's probably the very best piece of violence against women policy that has ever been written anywhere. And it's for that reason that I had some disquiet, not for once, going along with Scottish Women's Aid on the issue of consent. I thought that was an interesting debate that we did have about that and about the obligations placed. And mine were primarily predicated on the controlling and coercive behaviour, which is a very pernicious and nuanced abuse, invariably, of women. Police Scotland have these new powers now, and they describe them as providing an exceptional tool for use in exceptional circumstances, that it wouldn't constitute a routine response. And in many respects, I hope that is the case, Presiding Officer, because I had a number of concerns, about the circumstances where the suspect, and that's what it would be, the suspect was absent from the scene. The suspect had been arrested, there was insufficient evidence, and we had issues around what would actually happen about the administration of the domestic abuse notice. Now, I'm very grateful for the engagement that Scottish Women's Aid had and the Cabinet Secretary had about tightening that up, the parameters of that. I think there's an important role to go ahead with this implementation group to understand the particular challenges there will be with legislation that's got to apply equally to Shetland as it does to Stirling, and understanding the implications and the challenges that come from giving police extraordinary power to deny someone their residence. That's a power that normally be reserved for the court. And of course, it's a power that the court will pass comment on the next lawful day. That in itself, again, brings a very big challenge. In the limited time I have left, I do want to talk on the issue of police and judicial training. It's absolutely vital, absolutely vital. We know that sadly it's still the case that there are some inappropriate comments that are made from the bench, and understanding the consequences of men's violence against women, particularly the perniciousness of controlling coercive behaviour. I don't think we're quite there yet. Can I also commend White Ribbon Scotland, who engage with men and speaking out and taking action against men's violence against women and girls. It's undoubtedly the case that it is very much a gender-based violence, but it's one that affects everyone, and so one that remains a blight in our communities. Everyone should feel safe in their home, Presiding Officer. I hope this will go some way, providing some reassurance to women who go ahead. Thank you.
Call Liam MacArthur, please, also for 4 minutes.
Thank you, Deputy Presiding Officer. Can I start where John Finney ended and declare my interest as an ambassador for White Ribbon Scotland, Orkney. Recent events have obviously provided a graphic reminder of the context in which we need to view the legislation we've been debating this afternoon. The bill was necessary when it was first introduced to Parliament last year. It remains so today, and Scottish Liberal Democrats look forward to passing it into law shortly. Of course, much of the debate around Sarah Everard's brutal murder and the aftermath has focused quite rightly on what needs to be done to allow women and girls to feel safe on our streets and in our public spaces. That debate must and it will continue. However, it should go alongside the right of women and girls to feel safe in their own homes too. The grim reality is that this is often where they face the biggest risks and the greatest harm, never more so than during the pandemic, given the effects of the lockdown restrictions. That's why these measures to improve protection of those at risk of domestic abuse are so important, particularly where survivors are living with the perpetrator of that abuse. As I said during the Stage 1 debate, the principles of the bill broadly reflect the policy adopted by Scottish Liberal Democrats back in 2019. Despite that, the original bill was in need of quite a bit of remedial work. The Justice Committee heard concerns from various witnesses, not least the police themselves, about the practical implications, a lack of clarity, potential overlap and other similar concerns. These concerns have now largely been addressed, and I wish to also put on record my thanks to the Cabinet Secretary and committee colleagues, particularly Rhoda Grant, for the leading role she played. And I thank too, of course, witnesses Clark, Spice and all those who assisted the committee in carrying out our scrutiny in what, as the Cabinet Secretary acknowledged, was a truncated timeframe. In Scotland, current civil measures place the onus on the victim to apply for protective orders in cases of domestic abuse. Under this bill, police would be able to impose a protection notice and thereafter apply to the court for a protection order, which could place prohibitions on a suspected perpetrator of domestic abuse, including removing them from a home shared with a person at risk and prohibiting contact while the order is in effect. Today, Parliament has agreed further flexibility in the court's powers in relation to orders, and I think that is sensible. Creating a new ground for social landlords to apply to end the tendency of a perpetrator of abusive behaviour with a view to transferring the tendency to a victim is also a welcome step, and a not insignificant one, as John Finney rightly reminded us, helping us address, at least in part, the well-established link between domestic abuse and homelessness. So the provisions of this bill are both welcome and timely. Of course, they are only a very small part of the measures needed in response to the concerns we've heard voiced with such force over recent days. The lived experience of too many women and girls is not one that should be tolerated in 21st century Scotland. I look forward to seeing the recommendations of Dame Helena Kennedy and our working group on misogyny. However, of necessity, this is likely to focus principally on the case for a standalone offence on misogynistic harassment. Necessary, but not enough. So I welcome the proposal from my Scottish Liberal Democrat colleague Karen Lindsay for a commission able to build on the working group's findings, but able to look at the wider issues that need to be addressed here. Can I thank the Cabinet Secretary for responding positively to this idea when I raised it in the Chamber with him yesterday. I hope colleagues in other parties will also agree to look at how a commission might be established during the session of Parliament after the next election. For now, Deputy Presiding Officer, I confirm once again that Scottish Liberal Democrats will be very happy to lend our support to the Domestic Abuse Protection Bill at decision time this evening. Thank you.
We'll move now to the open debate and its contributions of 4 minutes, please. Fulton McGregor to be followed by James Dornan.
Thank you, Presiding Officer, and it gives me great pleasure to speak in today's debate as a member of the Justice Committee involved at all stages. This really is an important piece of legislation that builds on previous bills brought forward by this government that seeks to protect women from domestic abuse, such as the Domestic Abuse Scotland Act 2018. And it was certainly a different day that day when that bill went through, and there was people in the gallery. Presiding Officer, when I was working as a social worker, one thing that always struck myself and colleagues when dealing with a domestic abuse situation was the inherent unfairness on the victim, primarily women and children, to leave or flee the situation. Often the pressure was put on them to get out of the situation, and even sometimes child protection procedures and the like could be directed around that. How unfair is that? And it was always unfair. It's their home too, and this bill, I think, seeks to address this unfairness. Through the provision of DAPNs and DAPOs, the bill effectively removes the alleged offender and protects the person at risk. These orders allow immediate protection while the person who is the victim works out what to do next. And of course, as Liam MacArthur has already said there, Part 2 of the bill will also allow social landlords to end or transfer a tenancy of a perpetrator of domestic abuse to prevent a victim becoming homeless, enabling them to remain in the family home. As others have said as well, the bill, of course, was not perfect. And as it made its way through the stages was another good example of this Parliament working well to bring forward good legislation. We heard concerns, for example, about compliance with human rights and how the police might enforce these orders. I think that the amendments at stage 2 and those that we have just passed at stage 3 have sought to address this. And though, like colleagues noted in the stage 3 amendments, I do note the concerns raised by Scottish Women's Aid around the amendment to remove provision for person B to consent to a DAPO. But overall, Scottish Women's Aid and many others, such as Bernardo's, have been very supportive of this legislation, and I want to thank them for their briefings and input throughout the process. And I'll quote from Women's Aid briefing that was sent to members today. And the quote is that the bill marks a critical shift in preventing women's homelessness by removing and barring the perpetrator from the home and gives social landlords greater control to transfer tenancies to a victim or survivor, upholding women's rights to remain in her home, and we strongly urge all MSPs to support it. And, Presiding Officer, I want to stay on Women's Aid for a wee bit here. You will be aware that a couple of weeks back I raised with the First Minister the issue of what has effectively been a defunding of some women's aid services in North Lanarkshire. And this is a move that's been condemned by MSPs and MPs across the area and across all political parties. And I know that Women's Aid are seeking further meetings with the Council. I also understand there was a tendering process, but in the midst of a global pandemic where domestic abuse is on the rise and there's a broad trust in these services, there is now a real concern that women and children in North Lanarkshire will be left without much needed support. I know that the Council have not done this deliberately. Of course they haven't. Nobody would suggest that. It's likely the result of processes and procedures that are in place, but it does demonstrate the difference between policies and legislation made here and the reality of what's happening on the ground. A reduction in women's aid services is not in line with the aims of this bill or other legislation. I am aware that the Scottish Government funding continues for some services, but we are on the verge of passing this groundbreaking legislation at this time. I would ask the Cabinet Secretary if he could look into the circumstances in North Lanarkshire and consider if there is additional support that can be given to women's aid services there to ensure that they can continue with all services. Presiding Officer, I see that I'm coming right up to my time, so I want to close by welcoming this bill, saying again how grateful I am to have been a member that has been able to take the bill through all the various stages, and would urge all members to vote for it at decision time.
James Dornan, please, followed by Alex Neil.
Thank you, Presiding Officer, and I'm delighted to take part in today's incredibly important Stage 3 debate, and more so as it's on a subject that I care very much about, improving the support for survivors of domestic abuse. Since being elected, it's been an honour to work with and learn from two brilliant community organisations, Waves and the Daisy Project in Castlemilk, who do so much to support survivors of domestic abuse and male violence. Sadly, but undoubtedly, domestic abuse will be happening in every community across the country, in many cases exacerbated by this pandemic. And so local groups, such as the two just mentioned, will never be more important nor needed than they are now. And it's a truly damning statistic that on average over recent years, the police in Scotland recorded 60,000 domestic abuse incidents a year. And we all know that this is just the tip of a horrible, bloody, man-made iceberg. Therefore, we must do what we can to eradicate it and to support those affected. Presiding Officer, in this parliamentary term, as has already been mentioned, the government's already introduced world-leading legislation that makes psychological domestic abuse and controlling behaviour a crime. As a result, Scotland is now one of only a handful of countries across the entire world to have introduced dedicated legislation that covers not just physical abuse, but also other forms of abuse and behaviour which cannot easily be prosecuted under the existing criminal law. This bill builds on that important work by creating additional protection for people who are at risk of domestic abuse, particularly when they're living with their abuser. In 2019, I held a roundtable event in Parliament and a members' debate shortly after about financial abuse and how it should be fully recognised as coercive and controlling behaviour. It was clear from the discussions that domestic abuse perpetrators are very often the main claimant on benefit claims, the main signatory in contracts like car finance and in mortgages, leaving the person they're abusing having to rely on them. Saying off, it's hard enough for women, and of course, survivors are overwhelmingly women, to leave an abusive relationship through fear for the safety of their child or for their children, but having to worry about other issues such as their housing situation just adds to that feeling of helplessness and fear. Clearly, survivors should not be made to suffer further after having the courage to take action over their abuse. Perpetrators themselves who should be held accountable, they should be the ones removed from the home. Delighted that the bill will provide courts with a new power to do just this through the Domestic Abuse Protection Order. Presiding Officer, the bill also contains important provisions for social landlords and their tenants. I read a submission from the external consultation of the bill by the Glasgow and West of Scotland Forum of Housing Associations, who made an extremely important point. They wrote that it has long been a source of extreme frustration for social landlords and, of course, for people on the receiving end of domestic abuse that the law does not allow one of two joint tenants to be evicted alone. They therefore warmly welcomed the tenancy-related measures in the bill, including through the recovery of possession of the house in the case of a perpetrator who is a sole tenant, with the intention to then create a new tenancy in the name of the abused person. This provision in the bill will now prevent a victim becoming homeless and enabling them to remain in the family home if that is what they so desire. I agree with Scottish Women's Aid, who said that the bill as a whole could make an immediate and significant difference for women and children experiencing domestic abuse. Presiding Officer, it's fitting that this subject will be my last speech of this term. If I have the privilege of being returned, then supporting women and working to eradicate violence against women and girls will be first on my agenda. And I'll finish with this, Presiding Officer. During a time when this Parliament is under attack, it's good to be able to remind everyone of what has been achieved in just the last 7 days in here. Last week, we did redress for survivors of historical child abuse and care. Yesterday, the UN Rights of the Child Bill. And today, this fabulous piece of legislation. This Parliament can be proud of the work it consistently does, and particularly what it has done to support survivors of domestic abuse. And at decision time, we should all back this bill wholeheartedly. Thank you.
The final contribution in the open debate is from Alex Neil, and this is also Mr Neil's final contribution to this chamber.
Thank you very much indeed, Deputy Presiding Officer. As you say, after 22 years, this is my final speech to the Parliament as an MSP before I step down in May. And can I say, until my dying day, I will be very proud, like yourself, Presiding Officer, to have been a founding member of this Parliament, the first ever democratically elected Scottish Parliament. And I think we have proved that Jimmy Maxton was right when he said that a Scottish Parliament can achieve much more in 5 years for Scotland than Westminster could achieve in 25. Although having said that, I think we have a lot more to achieve, and I think hopefully in future years we will not be timid and be a bit more radical in what we are trying to do for Scotland. And we also democratise the Parliament internally in strengthening the role and power of backbenchers and the committees, and I hope that will happen soon. But may I take this opportunity to thank all the Parliament staff for all of the 22 years of exceptional friendly support and help. I want to thank all my friends on all sides of the chamber for their friendliness and support. I want to thank my own excellent staff over 22 years, including my existing staff who are helping me enormously in the constituency in difficult times. And particularly I want to thank my constituents in Airdrie and Shotts, a very fine constituency with very fine people, and it's been an honour to represent them in this Parliament for the last 22 years, both as a list member and as a constituency member. Presiding Officer, in 2 of the 4 ministerial positions I've held, I had responsibility for chairing the Scottish Government's national group on violence against women, a body which included representation from a wide range of local and national organisations. I believe that since 1999, every administration has made progress in dealing with the problem of domestic abuse and violence against women, although not always at the pace and scale we would all have wished. In supporting this bill today, we must rededicate ourselves to do more to reduce and I hope eventually eliminate this evil from our society. The measures contained in the Domestic Abuse Protection Bill that we are hopefully about to pass this afternoon will help us to do a lot more by preventing the enforced homelessness of abused women and their children, as well as help further protect through additional police powers those people who badly need our protection. But as the Cabinet Secretary and others have pointed out, passing legislation is extremely important, but it's not the total answer. And as I have to say, it's not always on the ground that we get the response that we need. And I just want to mention a couple of cases I've had of stalking by ex-partners that 2 women in particular have gone through horrific experiences with. And to be honest, the criminal justice system hasn't always been at its best in dealing with these cases, not through malintent, but just through not joined up enough. In one case where even before the pandemic, the abused person had been waiting a year before the alleged perpetrator appeared in court. He still hasn't appeared in court and won't appear until July. And that's just one example of where we need to do much more to drive the criminal justice system, the police, the prosecutors, everybody involved, to make sure that these women get the protection that we all want to see and that we are legislating for. Can I also say, as Fulton McGregor very rightly pointed out, and again without malintent, the decision by North Lanarkshire Council a few weeks ago to award a contract for local domestic abuse services to a national non-specialist organisation, I believe was a mistake. Under this contract, it will be the same organisation which provides services to both victims and culprits. This is a backward step and flies in the face of what we know about best practice in dealing with violence against women. And it will also result in defunding brilliant organisations like Monklands Women's Aid, who have done a huge amount of work in this field. And I, like Fulton McGregor, hope that North Lanarkshire Council, with good intent but bad judgment, will rectify this mistake. Presiding officer, it's not just about passing legislation, as I said. It's not even just about more training and more education. At the grassroots, we need to change the culture, the attitudes, the levels of awareness amongst all the institutions we need to fight against this terrible evil. And if I may make a recommendation to the Cabinet Secretary, I think his idea of an implementation board is absolutely excellent. But please ensure that other essential services like housing and welfare support are included in that implementation plan, because it has to be an integrated approach to helping women who find themselves in the situation that so many abused women and children do. Presiding officer, Scotland as a country must do better if we're to stop letting down these women and make a real dent in the number of women and children who are subjected to abuse and violence by male perpetrators. No civilised society can tolerate such violence. Stopping it must be a top priority for the new Parliament to be elected in May. And I'm absolutely sure that this legislation we're passing hopefully this afternoon will make a significant contribution towards that objective. Thank you very much indeed, Presiding Officer.
Thank you, Mr Neil. We'll now move to the closing speeches. And first of all, we have Rhoda Grant for 4 minutes, please.
Thank you, Presiding Officer. Can I thank committee clerks and staff, Vice and the legislation team who helped the committee scrutinise the bill and help frame amendments, which I believe improved the bill. Can I also wish Alec Neil all the very best for the future and thank him for his contribution to the Parliament and for his contribution combating violence against women, something I am sure he will continue to do, and he's right to say that there is much still to do in this area. Can I also join him in paying tribute to Women's Aid and for the work they do, not only on this bill, but day and daily to help victims of domestic abuse. And I truly believe that they should lead the charge against domestic abuse, and hope that sense can be seen and that they will retain contracts to protect women. We welcome the bill, and it provides much needed assistance to victims of domestic abuse. Domestic abuse is a blight in our society, where a perpetrator seeks to control their partner, and what's even worse, that this abuse is carried out by somebody who is supposed to love their victim. It happens behind closed doors, and it's difficult to prosecute because of the lack of corroboration. Up until now, victims have had to organise their own protection by getting non-harassment orders, and this means getting legal advice, which is not always available in legal aid, even if you can find a legal aid lawyer. This bill puts in place protection from the state for the very first time. It enables the victim to remain in the family home, as Fulton McGregor said in his speech, a real positive step in the right direction. We welcome this, but we need to remember that protection like this was available in other countries a decade ago, so we must really speed up how we work to protect victims of abuse. Neil Bibby talked about the need to protect children, which is sadly still lacking. We need to look at how we do this. It is disappointing to me that this bill will not provide them with protection in their own right, and this is something I am sure we will need to return to in the future. John Finney talked about the need for training of police and sheriffs, a point I made when I was speaking to amendments. Too often our courts allow themselves to be used to perpetrate abuse, giving contact to abusive partners to allow them to track and control their victims all over again and continue to damage the children of that relationship. Anyone who abuses their partner must be forced to relinquish access to their children until such time as they can prove that they have changed their behaviour and they are no longer going to damage those children and the children's parents. Presiding officer, this will not be the last word on how we deal with domestic abuse. There are a number of issues we must deal with, not least its impact on children. We must also take measures to ensure victims have access to a safe place and alarms. And this is especially the case in rural areas where assistance is not close by. We must teach boys and men that they cannot abuse their physical strength and power over their partner. This is something that is missing from our education system. Neil Bibby made the point that domestic abuse is not a women's problem, it's a problem with the men that perpetrate it. We must protect women from misogyny, something we failed to do with the hate crime bill last week. But until we do, women will continue to be subject to men's violence. In a week where we have seen in sharp relief men's violence against women, we must redouble our efforts to create a safe place and an equal society for women.
Thank you. Now call Adam Tompkins for around 5 minutes, please.
Thank you, Deputy Presiding Officer. This is the last speech I shall make to the Chamber, so I hope you'll forgive me if I offer a few remarks not only on the bill that we're about to pass, but also on one or two broader matters. The Domestic Abuse Protection Scotland Bill is an important measure which adds to Scotland's cutting-edge laws on domestic abuse. In a time when, once again, violence against women is much in the news and much in our thoughts, it is timely. I welcome the new bill. The Justice Committee has been anxious that the provisions in the bill will be practical and of real use to those, especially Police Scotland, who will have to make the new powers work. And we've also been concerned to ensure that the provisions will operate compatibly with convention rights. This is the third government bill in quick succession that the Justice Committee has examined, following hard on the heels of the Defamation Bill and, of course, the Hate Crime Bill. All three of these bills touch directly on our fundamental human rights. All three make significant changes to the law, and all three have found the Justice Committee working hard, but working together to agree across the parties reports that I hope have improved both the quality and the effectiveness of Parliament's legislation. Presiding Officer, I've been the convener of the Justice Committee for only a short time, but I have enjoyed it immensely. And despite not being able to vote in the end for all of the legislation that we have examined, I am proud of the work the committee has done while I have served as its convener. Presiding Officer, Parliaments exist to do three things: to represent the interests of our constituents in debates on matters of public importance, to hold the government to account, and to make legislation. I have been studying and writing about parliaments for all my adult life. I've been a member of this parliament for 5 years, and before that I was an advisor in the House of Lords for 6 years. It was there, in the House of Lords, where I saw at first hand what parliamentarians could do to improve laws, even if they were not in sympathy with the political preferences of the government of the day. I tried to apply those lessons to my own practice as a parliamentarian here. And as I look back on the last 5 years, I remember at the beginning of the session, the work I and my colleagues did with Pauline McNeill and Alison Johnston to make the Child Poverty Bill stronger. I remember the work we did with Lewis MacDonald to make the Planning Act stronger. I remember the work Bruce Crawford and I did with the Finance Committee on the common frameworks that the UK internal market needs now that we have left the European Union. And turning to more recent matters, I will long remember the work I did with Liam MacArthur and with my good friend Liam Kerr and with others to make the hate crime bill, well, not stronger perhaps, but certainly a lot less dangerous than it would otherwise have been. Child poverty, planning law, common frameworks, hate crime. That's a broad range of subjects, Presiding Officer, but there is one common thread. All were examples of cross-party working. Now, Better Together is the name of the campaign that first brought me into Scottish politics, and nothing that I have seen or heard in the last 10 years has made me change my mind about that. We are better when we work together, and we make better laws together. When it comes to the other key function of Parliament, Presiding Officer, holding the government effectively to account, I'm afraid that the Scottish Parliament still leaves a very great deal to be desired. In my view, this is not because we lack powers. It's more disturbing than that. It's because too many of us lack the will to use them. But today, Presiding Officer, this debate is not about holding the government to account. It's about making law. The Domestic Abuse Protection Bill is, I hope, good law. It will help make women safer. It will help Police Scotland tackle the scourge of domestic violence. It will be useful on the ground. It will be compatible with convention rights. I am glad to have played a small role in making it. I commend it to the Chamber, and I look forward to voting for it at decision time this evening. Thank you very much.
Thank you, Mr Tompkins. I now call Hamza Yousaf to close the debate for around 6 minutes. Please, Cabinet Secretary.
Thank you, Presiding Officer. As others have already referenced, this Parliament is at its best when we unite. That is not to pursue false consensus for the sake of it, but for when we believe there is an ideal that is greater than our individual parts. Then we come together and enact and give passage to transformational law. And we have seen many examples of that, just even in the last 24 to 48 hours with that really historic moment of the UNCRC being incorporated into domestic law, the historic redress bill, I would add the hate crime bill, but many other pieces of legislation being passed by this Parliament through unanimity or consensus, with a large majority from this Parliament backing it. And again, I think it is right that as we end this parliamentary session, that we end on a point of unanimity. There are other bills to come next week, but this is the last government bill to come at this Parliament session. I'm proud that it is the Domestic Abuse Protection Scotland bill that we end on in relation to government legislation. Let me turn to some really important points made by colleagues across the Chamber. Liam Kerr, Neil Bibby, Liam MacArthur, John Finney, and many others, Adam Tompkins, many others in fact, right to remind us of the context we are in. The last week we have heard absolutely harrowing testimony from women about the dangers that they face, from men. Somebody in the debate mentioned that women were vulnerable. That's not the case, actually. It is men's violence, men's abuse of power. That is the problem, not the issue of women's vulnerability, as I would see it. And some of the testimonies we have heard, as I say, have been harrowing, but they've also forced, I think, a lot of men, I can certainly speak for my own behalf, to take notice of, in my case, the dangers, for example, my wife has told me that she faces. She told me the other week that she was taking my daughter for a walk in broad daylight, and a man was behind her, and as she turned the corner, she felt the need to shout out, although I was at work, I was here in the chamber, she felt the need to shout out, "Hamza, just wait for us." Incredible. I would never think to do that on a walk, in darkness, let alone in broad daylight. I've never felt the urge to have to clench my keys in my pocket. Never felt the urge. I've never felt the urge to, after in pre-COVID days, of course, after a night out with my friends, to say to them, I'll text you when I'm back home safely. I've never felt the urge to have to pick up my phone and pretend I'm on a call on my way back to my car, just so people are alert or aware that I'm speaking to somebody. Never felt the urge to do any of that. And that is something that is probably fairly common practice, as I have heard recently from many women as they shared their testimony over the last week. Of course I have.
Ruth Maguire.
I thank the Cabinet Secretary for taking an intervention. I suppose as he makes his remarks, it just strikes me that over the past 5 years, almost every time a woman's murdered or something terrible happens, we stand up in this Parliament and share what's happening. So it's not something new, and I wonder how he responds to that. So while he shares the stories from the women in his life, that actually these are stories that we have to tell over and over and over again. And I think it's just important to acknowledge that although this last few weeks has been terrible and it's been painful for people, that actually it's been like this for ever such a long time.
Yes, not for years, not for decades, for centuries, perhaps even longer than that. And I sense a sense of frustration from Ruth Maguire as she's speaking, and rightly so, because we have to respond as a government, but also, I think, as men. We do have the misogyny in the criminal law working group being taken forward by Baroness Helena Kennedy. And I think she will provide some helpful legislative solutions to some of the issues that are raised. But as many members have mentioned, Rhoda Grant there at the end in the closing for Labour in particular, that this is not just about legislation. It must be about education. And a number of my colleagues, the male colleagues who have stood up, have referenced the fact they are members of White Ribbon Scotland. Can I commend the work of White Ribbon Scotland and say that we must take up that challenge from Rhoda Grant, from I'm sure many other women across this chamber, which is, educate your sons, educate your brothers, educate the males and yourself about why it is that women feel that men are a danger to them. And we must modify our behaviour. And I certainly would like to learn more on that journey. I think I've done some of that, but I think there is an immediate need not just to learn, but to act. And I hope that the Domestic Abuse Protection Bill is a demonstration of that action, in a small way, but a significant way, nonetheless. Can I also just reference John Finney's comments? Although I'm sure he's going to make other debates, other contributions in other debates, this, I think, would be his last contribution from a justice perspective. And I have known John Finney for many years. I've admired him and respected him as a friend. He has one of the strongest moral compasses I know. I was deeply sad when I learnt of the fact that he left my own party. However, he's always worked constructively across this chamber, always in the pursuit of justice. And as a member of the Justice Committee and the convener of the Policing Subcommittee, he has been formidable, he has been forensic, he's been thoughtful, and I, for one, will miss him greatly in this chamber. Other points were made by a number of members, and I know time is short, but certainly points made by Fulton McGregor and Alex Neil were important about North Lanarkshire Council. They've both challenged the government to look at that situation. I will do that. Of course, we fund local government to fund local services, but nonetheless, I'm happy to look into this situation because of the importance and, unfortunately, the prevalence of domestic abuse in our society. But the importance of tackling domestic abuse, I will look at that issue. James Don was right, 60,000 domestic abuse incidents attended to by Police Scotland. We must do better. Alex Neil made a really, again, thoughtful, valedictory speech. He, again, is somebody who is formidable. The opposition might breathe a sigh of relief that they no longer have to deal with Alex Neil, who can articulate himself with great strength. I suspect we will breathe a greater sigh of relief than the opposition will. But he has always given his challenge to government very, very fairly. And can I commend him for doing that once again in his valedictory speech. Even now he is stealing the thunder and the attention, even though he's not in this chamber, and quite right to do so. He made some fair comments about how the criminal justice system must do better. He referenced a constituency case that he had dealt with in relation to stalking. And can I tell him that all of the issues he raises fairly are ones that are being discussed by Police Scotland, the Scottish Courts and Tribunal Service, and government and many others as part of the Victims Task Force. Can I wish Alex Neil the very, very best. To end on, I thought Adam Tompkins again made a very thoughtful speech. Can I congratulate him on the 5 years of service in this Parliament? He's shown himself to be a very effective committee convener. Perhaps the best compliment I can pay him is that I suspect many of his opponents will breathe again a sigh of relief at his departure. And he mentioned nothing that he has heard in these 5 years has convinced him to change his mind about supporting the union. I do remember, of course, there was an Adam Tompkins who supported independence, so we won't give up hope, perhaps, just yet. Can I end by giving a quote from Scottish Women's Aid? It comes from their 2015 publication, Change, Justice and Fairness. It was titled, Why Should I Move Everywhere and Everything Because of Him? The research cast light on the massive impact of domestic abuse and the impact it has on the living situations of women. And I'll quote directly from the group of women involved in that publication. They say, we came together as a group of women from different backgrounds and life experiences, and we began sharing our stories. We found strong similarities in how we had been treated. We were determined to prevent other women and children in the future from having to live through what happened to us. We have done nothing wrong, but were forced to leave our home, either by the perpetrator or by the housing system that expected us and our children to become homeless. Presiding Officer, we must do better. For those women who feel that they have to flee their home to escape domestic abuse, we must do better. For those women who believe that they have to choose between their own safety and then abandoning their children, we must do better. To ensure that women are not left homeless by the scourge of domestic abuse, then we must do better. This bill, the Domestic Abuse Protections Scotland Bill, I hope is a demonstration of this Parliament, this Government, this Chamber doing better. It gives the powers to Police Scotland, to Scottish Courts and Tribunal Service, to ensure that safety is provided to victims of domestic abuse, even when the criminal threshold has not been met. So never again should we have that stain in our collective conscience that victims of domestic abuse, predominantly women, have to flee their home in order to protect themselves from the risk of domestic abuse. And in that vein, I'm delighted to hear from all political parties that they will support this bill, and I commend the Domestic Abuse Protection Scotland Bill to this chamber and move the motion in my name.
That concludes the debate on the Domestic Abuse Protection Scotland Bill, and it's now time to move on to the next item of business.